Thank you very much. Thank you
I
very
recognize
much.
the gentleman from Texas.
Thank the chairman. Mr. Smith, how many members of Congress or the Senate did you subpoena phone toll records?
As I sit here right now, I do not recall a specific number.
Is this the complete list right here? Well, let me ask you this. Am I on this list? Did you target my records and subpoena my phone toll records?
My understanding is your records were subpoenaed by prosecutors before I became special counsel.
Well, staff would put this up on the screen. I'm thankful for the great staff who discovered the email where I learned for the first time a few weeks ago that my phone records were indeed targeted. We called AT&T and we've learned that they were given to the Department of Justice, as this email indicates, because I have been in communication with Scott Perry, one of my colleagues here in Congress, who literally had his phone taken from him in front of his family. And of course, as we've already talked about in this document, it talks about you could be in violation of the privilege by even obtaining and possessing this information if the member objected to the disclosure. This happened 4 years ago in May of 2022, and I couldn't object because I didn't know. I didn't know until about 3 weeks ago. My question here is, was there any limits to your investigation or the investigation that preceded you, Mr. Smith? Because as egregious as a violation of separation of powers this is, as an egregious and abuse of power it is, it's far more concerning you are clearly targeting American citizens for merely being conservative or supporting the president. We've got memos that we've already been talking about in this hearing from April 2022 that preceded you that establish and open the investigations, one of which has Attorney General Merrick Garland's signature on it. And the focus was the electors. Now that was 6 months before you were appointed. You testified earlier, you met and interviewed Merrick Garland and Deputy AG Lisa Monaco. And you briefed the AG and deputy multiple times. Did you brief them on the electors and the prosecution of their supposed crimes?
Did I? I'm sorry.
Did you brief them on the electors and their supposed crimes?
I don't recall specific conversations, but I'm sure that in the course of briefing them, I discussed.
Wasn't that the purpose of the entire investigation as it was set out? Because putting aside that in 1960, it was already talked about, my friend Mr. Tiffany, that Hawaii put forward an alternate slate of electors, the investigation pivoted to President Trump and, frankly, anybody who knew him. Do you know who Cleta Mitchell is?
Yes, I do.
Welcome back to the channel. If you've been following the ongoing legal sagas in Washington, you know the weaponization of our justice system has been a massive concern for millions of Americans. Today, we are looking at one of the most explosive congressional hearings we've seen all year. Representative Chip Roy from Texas went toe-to-toe with Special Counsel Jack Smith. And folks, Roy absolutely dominated the room. What makes this clip so crucial isn't just a drama. It's about fundamental constitutional rights. We're talking about separation of powers, secret subpoenas of sitting members of Congress, and the targeting of hundreds of conservative organizations across the country. Chip Roy framing this as a direct assault on liberty was pure perfection, and it's something every single American needs to pay attention to. Before we dive into full video, do me a huge favor. Smash that like button, hit subscribe, and ring the notification bell so you never miss an update. If you believe in equal justice under the law and strong constitutional oversight, drop in the comments right now. Let's get this video out to as many people as possible.
She's an election lawyer that was involved in filing an election contest on behalf of President Trump in Georgia in December of 2020. A 64-page complaint with over 1,100 pages of exhibits, witness affidavits, and expert witness reports documenting thousands of votes cast in violation of Georgia law, but which were nevertheless included in the vote totals. Now, notwithstanding the disposition of the cases that was filed, is that a criminal act? Filing an election contest on behalf of a candidate for office, a client. Is that a criminal act, yes or no?
No, in fact, we stated...
So why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election contest was filed and after the presidential electors were certified? What about Jen Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them that would warrant monitoring their phone records 2.5 years after the 2020 election was certified?
With respect to Sidney Powell, she is one of the co-conspirators alleged in the indictment. I don't know what you mean by monitoring, sir, if you're talking.
Well, there were some 400 plus Republican conservative groups and leaders who were targeted by your investigation. Their financial records were obtained, records of the RNC, the Trump campaign, Cleta Mitchell, the Conservative Partnership Institute, the America First Policy Institute, NRCC, NRSC, PACs, conservative groups, people all across the country, citizens, because we hear a lot about members of Congress. And we should, because of separation of powers and the egregious abuse of power. But what we're not talking about enough, in my opinion, are the American citizens that have been targeted. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much so in your abuse of power that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution, but you continued to sign your name on court filings until the time you resigned from office in January of 2025. A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment. I yield back.
Gentleman yields back.
Did the gentleman have the opportunity to respond?
If the gentleman wants to respond, he can.
With respect to the last point, Judge Cannon's order specifically limited her finding to that proceeding. So there would be nothing improper about continuing to litigate the cases in Washington, D.C. And with respect to Florida, there was nothing improper about taking an appeal of that very decision.
That hearing right there was an absolute victory for Chip Roy, for Congress, and honestly, for anyone who still cares about the Constitution. What we just watched was a brilliant masterclass effort in putting the Department of Justice on defensive and exposing how far out of bounds this entire investigation went. First off, let's talk about the sheer audacity of subpoenaing a sitting congressman's phone records. Chip Roy revealed that his own communication logs were quietly snatched up by prosecutors, and he didn't even find out until 3 weeks ago. That completely destroys the separation of powers. The Constitution specifically protects members of Congress, so the executive branch can't spy on them or intimidate them while they do their jobs. Jack Smith tried to dodge responsibility by claiming those subpoenas happened right before he officially took over as special counsel, but Chip Roy wasn't buying it for a second. Jack Smith inherited that team, used those records, and continued that exact same playbook. You can't take over a prosecution built on government overreach and pretend your hands are clean. Then Roy moved in on the weaponization against everyday attorneys and conservative groups, and this was where he truly shined. He asked Jack Smith directly if filing an election contest on behalf of a client is a crime. Smith had to sit there and say no, because challenging election results in court is standard legal procedure in America. Yet, under this investigation, attorneys who filed legal complaints were treated like criminal co-conspirators, and their private records were monitored years after the fact. When you start criminalizing legal representation, you're tearing down the Sixth Amendment right to counsel. And it wasn't just lawyers. Roy pointed out that over 400 conservative organizations and grassroots leaders, from the RNC to local policy institutes, had their financial and phone records dragged into this net. This wasn't a focused legal investigation. It was a broad dragnet designed to map out and pressure the entire conservative movement in America. As Roy rightly pointed out, members of Congress at least have a platform to fight back, but millions of regular citizens don't have that luxury when a rogue prosecutor targets them. Finally, ending it with the fact that Jack Smith's appointment was ruled unconstitutional by a federal judge in Florida was the ultimate knockout blow. Jack Smith tried to defend continuing his work in D.C. on technicalities, but Roy laid it bare. Continuing to prosecute citizens under an invalid, unconstitutional appointment crosses a massive line. Chip Roy walked into that room principled, sharp, and loaded with facts. He didn't let Jack Smith hide behind technical legal jargon or bureaucratic non-answers. He simplified a massive, complex legal mess into a clear reality. This was about government overreach versus constitutional liberty. Roy controlled the entire narrative from start to finish, stood up for the American people, and won that hearing by a landslide. At the end of the day, hearings like this remind us why congressional oversight is so vital. Chip Roy stepped up, asked the tough questions, and exposed the truth. I want to hear from you. What was the most shocking reveal in this clip for you? Let me know your thoughts down in the comments below. Don't forget to like, share, and subscribe for more unfiltered political breakdowns. Stay vigilant. Stand up for the Constitution, and I'll catch you in the next video.